Hello, everybody, and welcome to History/Law Bite number 200, dated February the 28th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Cherokee Nation versus Georgia, 30 U.S. 1, 1831. Cherokee Nation versus Georgia was a very significant U.S. Supreme Court decision handed down during the Marshall Court era that spoke on the subject of the tribal sovereignty of Native Americans. Like many Native American nations in the 19th century, the Cherokee struggled to maintain both their tribal lands and their ways of life against the power of both the U.S. states and the U.S. government. The struggle was real. And also, like many Native American tribes, the Cherokee adopted many European American ways in order to gain favor from, the majority white population. But alas, it was to no avail. And ultimately, we know how all of this would turn out. Okay, so in the case of Cherokee Nation versus Georgia, we see long-standing struggle between the Cherokee Nation and the state of Georgia. All right. After the Revolutionary War, the Cherokee people indeed engaged in a lot of conflict with the state of Georgia, which resulted in a peace treaty in 1791, where the state would respect these tribal lands, but this was short-lived. After 1802, the state of Georgia essentially agitated the slow eradication of ownership by the Cherokee to their lands, effectively encouraging settlers and others to acquire those lands, thus loosening the Cherokee's hold on it slowly but surely, all right? And by 1828, okay, the state of Georgia was getting very frustrated with the slow process of these land acquisitions, and followed that with the enactment of many very anti-Cherokee laws designed to remove them from these lands and essentially extinguish and exterminate their culture as well. All right, ethnic cleansing 101, if you ask me. But the Cherokee were not about to take this line down. Indeed, with the support of their chief, John Ross, and prominent U.S. Attorney William Wirt, the Cherokee decided to seek judicial action to prevent the further removal of their people from these lands and to stop the state of Georgia in its tracks. As such, Attorney Wirt asked the Supreme Court for an injunction to stop the state of Georgia in the execution of these laws to remove the Cherokee people from their lands. He made the argument that the Cherokee were a sovereign nation as recognized by the U.S. in its making of several treaties with the Cherokee people, okay? And the state of Georgia argued the exact opposite, that the Cherokee were not a distinct nation because they had neither a constitution or a distinct system of government in any way, shape, or form. So the questions presented to the Supreme Court were as follows. Did the Cherokee constitute a foreign state under the meaning of Article 3 of the U.S. Constitution, which establishes the Supreme Court's original jurisdiction? And if so, did the Supreme Court have the authority in hearing this case to issue an injunction to the state of Georgia to stop them from executing their Cherokee removal laws? Okay? And the Supreme Court ruled via Chief Justice John Marshall that the Cherokee were not a foreign state within the meaning of Article 3 of the Constitution, and the court did not thus have the authority to issue an injunction. Marshall reasoned that while the Cherokee Native Americans were a distinct political society with their own laws and governances, in being able to manage their own affairs, okay, they were not a distinct foreign state as what would be required under Article 3 of the Constitution, as the Cherokee were essentially a domestic dependent nation within the United States. Thus, while the tribe had some form of sovereignty, it was not a completely sovereign, independent country as what would be viewed by Article 3 of the U.S. Constitution, what would be viewed under Article 3 of the Constitution. Okay? So while the Cherokee were indeed a distinct political society, they were not a foreign state within the meaning of Article 3 of the Constitution for the court to have jurisdiction over this case. And Marshall also went on to further reason that even if the court did have jurisdiction, issuing an injunction would be judicial overreaching, essentially that the court would be overstepping its power in handcuffing the authority of the Georgia legislature to execute its laws, okay? In Marshall's mind here, this was more of a political issue rather than a judicial one. And thus the Supreme Court wouldn't have been the best venue to issue an injunction here, all right? I suppose Marshall probably felt that the issue should have been resolved locally more so than from the federal government. Interesting conclusion on his part nonetheless, but that was the rationale he gave for denying the injunction, as he felt the Supreme Court would be overstepping its boundaries, and this was something better exercised by the political branches of government rather than the judiciary. Okay? So again, the 2 points. Okay? Even though the Cherokee were a distinct political society, they were not a foreign state within the meaning of Article 3 of the Constitution, because they were a domestic dependent nation upon the United States. Essentially, the United States retained the sovereignty over the Cherokee people. They were essentially wards, like all Native Americans, to the U.S. federal government. Thus, were not a foreign country within the meaning of Article 3 of the Constitution. All right? And the injunction couldn't be issued even if the court did have jurisdiction, because Marshall felt that this was better exercised by the political branches of government rather than the judicial department. All right? But not everybody agreed with Marshall's logic. Indeed, Justices Smith Thompson and Joseph Story dissented very strongly from Marshall's opinion, arguing that the Cherokee people certainly could be viewed as a foreign state within the meaning of Article 3 of the Constitution, as the United States viewed them as competent enough to make treaties and other contracts. And with that being said, Georgia's actions here, which had the intent of basically total annihilation of the Cherokee people, pushing them off of their land and further westward or wherever, certainly a warranted judicial remedy here in the form of an injunction. All right? So they dissented very strongly from Marshall's opinion, which was seen as, very dismissive of the concept of true Native American sovereignty here. All right? So as a result of this decision, all right, the Cherokee did not have the proper legal resource, at least at this very junction in history, to stop the state of Georgia to force them off their land. However, they would not give up and once again challenged the actions of the state of Georgia in the case of Worcester versus Georgia in 1832. All right? Contained in a separate video. So that, folks, is Cherokee Nation versus Georgia. 30 U.S. 1, 1831. It's an interesting case, kind of a sad one, if you ask me, that definitely weakened the concept of tribal sovereignty for Native Americans. So I thank you so much for listening to this video. Hope you gained a thing or two from it. If you have not subscribed to my channel, Please do so now if you would. Just hit that little red subscribe button and we'll be in business. If you'd like to donate to my channel financially, links are provided on the main page. Thank you again for listening. Your support is appreciated more than you will ever know. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.